the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone, and welcome to the Fair Housing Insiders Case Files, episode 26, with Leslie Tucker, the principal of Williams, Edelstein, and Tucker, and I am your host, Jonathan Sarr. Today's case: how should a property handle reports of resident bullying or harassment? This case highlights exactly what you should not do. Leslie, can you please share with us the missteps that the manager took and how that led to a judgment and a fine?
Sure, absolutely. So, Jonathan, this case was filed on behalf of a resident with a disability. Her name's Laura. Laura, who has cerebral palsy and is sight impaired, has a 21-year-old daughter who she lives with who has Down syndrome. Early after moving into this particular property, several of the residents that lived there made offensive comments, gestures to Laura, basically telling her, you don't belong here. Your daughter belongs in an institution, calling her mentally retarded, really offensive statements. Some of the residents even went directly to the manager and complained to the manager that they thought that Laura and her daughter should not be living in that community. They also submitted some noise complaints about the daughter. Laura also allegedly, made the manager aware that this was going on, that they were being harassed, not being permitted by some of the residents to use some of the common areas. But he allegedly informed her that he does not get involved in resident disputes. So less than a month after they moved in, the manager spoke with their advocate and told her that he didn't think that the daughter was capable of independent living, and also claimed that his insurance company wouldn't cover the property with her living there. Of course, the Department of Justice stated that this was not, in fact, correct, but I don't have enough information to know either way. The manager allegedly informed Laura that if she didn't move out, that she would ultimately need to, but if she did agree to move out, he would refund her security deposit. Ultimately, they did not move out, and the manager ultimately never terminated her lease. So they were allowed to kind of ride out till the end of their lease. But Laura alleges that during the entirety of their tenancy, their neighbors continued to harass her and her daughter was kind of forced just to stay inside all the time just to avoid the nasty comments. They allege that the manager never did anything, never agreed to take action, never told anyone to stop, and he did non-renew the lease at the end of the term and provided no explanation for that. They filed a fair housing complaint. HUD did find that they thought that there was reason to believe a violation occurred here. The case was moved to federal court. Ultimately, this case did settle. The housing provider was required to change their policies, take training, a number of other things, and also had to make a payment of $40,000 to Laura, her daughter, and her advocate. So it was a fairly significant damage award.
Yeah, unfortunate case. You really can feel for Laura and her daughter in this particular situation. So you mentioned at the beginning of your summary of the case that the landlord didn't want to get involved. And we know that in housing, you're dealing with all kinds of people, all kinds of backgrounds, all kinds of personalities. disputes happen. That's just the nature of being in a community. Why must a landlord get involved in these disputes?
Which is a great question. And you're absolutely right. These types of, conflicts, they happen all the time, residents butt heads. There's generally not a law that requires a landlord to jump in and mediate disputes and get involved when residents butt heads. The exception to that is when you are butting heads and the conflict is about a protected category. And in this case, the protected category was obviously disability. The harassment was about the daughter's disability. They were making fun of her. They were calling her names. They were making, really offensive statements and gestures. So in this instance, since the conflict was about a disability, yes, the landlord has a legal obligation under the Fair Housing Act to get involved. This is not one that they can just sort of stay out of, say, no thanks, I don't really want to get involved. They have to. And they have to get involved to whatever extent they need to make the conduct stop. So if that means issuing lease violations, if that means just having, a meeting, a counseling session, whatever that takes, whatever it looks like to make the conduct stop, that's what they are required to do.
Got it. Okay. Thank you. Now, in your summary, you also mentioned that there were some noise complaints that the residents filed. So if their daughter was legitimately causing excessive noise, wouldn't the landlord be justified in taking action against the household?
Potentially, yes. Sometimes disabilities do result in conduct that disturbs other residents. I mean, this happens. Sometimes it's in the form of noise. Sometimes it's in the form of kind of other types of conduct. So is a landlord justified in taking action against those tenants? I would say yes, but I think some things have to happen first. And in this case, the landlord kind of jumped in after the noise complaints and said, look, you need to come up with a plan to make this stop. You need to come up with a plan to handle the noise when the daughter gets into these situations where she does make a lot of noise. There have to be accommodations made when conduct is resulting, when a disability is resulting in that type of conduct. That could be extra chances. You have to just be kind of patient and understanding, and encourage the household to find ways to, I don't know, make it stop, make it better. Yeah. And then at some point, yeah, I mean, a landlord probably does have justification to take action if the conduct is continuing to violate the lease and to disturb other residents.
Okay, very good. That's a sensitive case. Thank you for the explanation. Lots of lessons learned for our community. Once again, thank you for your expertise, Leslie. So thank you to our community as well. We appreciate your support of this channel and of this, and hearing these cases and your feedback as well. We look forward to next time. Take care, everyone.